it is important that when we comment upon the decisions of judges, we remember that those judges are both impartial and independent, and they are entitled to reach the view that they have reached. We are fortunate in this House to have one of the finest judiciaries, I believe, in the world. And
this is why Theo Usherwood's analysis was rather better than I allowed a moment ago, because Downing Street are going to try and spin a people versus Parliament line, whereas in Parliament all members of government will have to do what Geoffrey Cox has just done and insist that judges are impartial, unbiased and therefore to be trusted and respected.
Southwest, both for securing this urgent question and indeed her work in this matter. Yesterday's decision of the Supreme Court, and I give credit to all those who brought the cases, was the most damning judicial indictment of a government in modern times. That the decision to advise Her Majesty the Queen to prorogue Parliament was unlawful. This government stands in shame, tendering illegal advice to our monarch and not even able to uphold that most basic but most important of principles,
unlawful, not illegal. Sorry.
By the rule of law. And what we know from yesterday's leaked document is the Attorney General said his advice on the question of the law was that this was lawful and within the Constitution, and that any accusation of unlawfulness, he said, were motivated by political considerations. If that is in any way accurate as to his full advice, he was wrong on both counts. Yes. His close interest simply wasn't enough. Now, I'll ask the Attorney General a number of questions. Can he confirm why it was? The government gave no witness statement to the court, and indeed the court was left in a position where it said no justification for taking action with such an extreme effect was put before the court. Why not? He talks, Mr Speaker, about respecting the decision of the judges, but the Cabinet Office Minister was on the radio this morning saying that he disagrees with the decision.
Incredible.
Tell us which parts of the judgment the government disagrees with. And in his considerations over the next few days about the publication of this advice, can I just give him a simple piece of advice, a simple suggestion? Just publish it and make it open to Parliament and the public. Mr Speaker, on this Attorney General's watch, the government has been found in contempt of Parliament. Now it has been found in contempt of the law.
Incredible.
Doesn't he just accept he hasn't got a shred of credibility left?
I don't know whether in his practice, when he was at the bar, he felt that just because he'd given advice that might not have been upheld by a court, he had no credibility. That is an absurd and ridiculous proposition. Furthermore, it was advice that was agreed with by the first instance court in Scotland and by the Lord Chief Justice of England. Is the right honourable gentleman calling for his resignation as well? Is he calling for the resignation?
I don't know if that's strictly true, but of course I haven't seen the legal advice, so I can't comment, which is kind of the whole point.
His resignation. I will say this, Mr Speaker.
Order. The Attorney General will just resume his seat momentarily. I should be deeply obliged to him. The Attorney General has a distinctive and resonant baritone, which is well known throughout the House, but it is a challenge even to him to be fully heard if there is constant catcalling. There will be ample opportunity for colleagues to question and probe the Attorney General, of that they may be assured. But I wish myself to listen to his mellifluous tones. The Attorney General.
I will say this, Mr Speaker, for the Scottish Nationalist Party and for the Honourable Lady, if I may. Whereas in the Honourable Gentleman's case, no shameless piece of cynical opportunism is left on the floor, the Honourable Lady is a lawyer and a Queen's Counsel, and she knows it is the most puerile, infantile of criticism to say about a lawyer whose advice has been upheld by courts right up the way to the Supreme Court that somehow or other that advice he should be held culpable for. The fact of the matter is...
Again, it's an astonishing position that Geoffrey Cox is adopting while still not having shared what that advice was. You just defend it by publishing it, I would have thought.
Of last resort, ultimately disagree with it. But in doing so, they made new law, as they were entirely entitled to do.
Also, more basso profundo, surely, Mr. Speaker, than baritone.
Mr. Dominic Grieve.
Thank you, Mr. Speaker. I'm extremely mindful of the difficult task that my right honourable and learned friend has as an Attorney General in providing advice to government. And indeed, I'm sorry if his legal advice has been partially leaked, because he is entitled to give advice in private, without which he cannot do his work. And I would also say that for him to get the law wrong in an area of difficulty is not necessarily something to be held to his discredit. But he may agree with me, but one of the issues in this matter was not just law, but propriety. And the propriety went to the unconstitutional or constitutional nature of the act of prorogation itself, in view of the motivation of the government for doing it. And in those circumstances, I was struck by the fact in the leaked document that his opinion is referred to as believing it is constitutional, when I'd understood from comments he made as far back, I think, as July, when prorogation was first being mooted in order to achieve a no-deal Brexit on the 31st of October, that he considered that such an act would be unconstitutional. And I wondered, therefore, if this isn't one issue which he ought not to clarify.
That sound you can hear is journalists scurrying to find the evidence of what Grieve has just stated.
Will understand that it is not right for the Attorney General, for any Cabinet Minister, to comment upon leaks of matters that have occurred within Cabinet, be they accurate or inaccurate. It would be setting a wholly undesirable precedent. But let me say this. The position some weeks ago was being mooted that Parliament might be prorogued from the beginning of September, or even earlier, until the 31st of October. I say straight away to my right honourable friend, if that had been the proposition, I could not have stayed in the Cabinet whilst it was done.
That's very different. Very different. Hilary Benn.
Thank you very much indeed, Mr. Speaker. Does the Attorney General believe that yesterday's judgment of the Supreme Court represented a constitutional coup? And if he does not share that view, could he explain to the House why he thinks that that is wrong?
A reference, of course, to Jacob Rees-Mogg's reported description of the Supreme Court finding.
Right honourable lady, right honourable gentleman, right honourable gentleman, right honourable gentleman will know that I do, and I don't believe that anybody does. These things can be said in the heat, of rhetorical and poetical license. But this was a judgment. This was a judgment of the Supreme Court of a kind which was clear and definitive. It often happens that governments lose cases. We didn't agree with it because, of course, we argued against it. But we accept the ruling of the Supreme Court, and we are proud that we have a country capable of giving independent judgments of this kind.
Bob Neal.
Thank you, Mr. Speaker. Can I welcome the Attorney's very clear statement of the importance which he, and I'm sure the whole government, attaches to the impartiality and independence of the judiciary. That is most welcome. Can I also say to him that many lawyers might well have given exactly the same advice as he did on the weight of precedent. Does he accept, however, that it is most important that the convention, that the advice that the attorney gives to government is not leaked and is not disclosed, should not be lightly set aside? But would he also perhaps consider that it's rather regrettable that such an important matter, which warrants very careful and calm and considered language and discussion, should be used for the purpose of rather unworthy ad hominem attacks and a party political knockabout when so much is at stake?
Well, I'm grateful to my honourable and learned friend's question there. I do, of course, agree with him that Legal advice, and particularly the role of the attorney, is always difficult because one polices and intersects a very difficult line between giving advice of an impartial and politically impartial character and being a political minister. But I hope that I've endeavoured to do that with all of the conscience and candour at my disposal. And when I say to the House, as I do today, I accept we lost, we got it wrong on the judgment of the Supreme Court, but it was a respectable view on the law to take, and that view was taken by 4 out of the 7 judges who'd opined up to the point of the Supreme Court. The Supreme Court has made new law. Let's be absolutely clear. From now on, the prerogative power of Her Majesty, advised by the Prime Minister, can now be the subject, justiciable subject of the court's control. And that was a judgment that the Supreme Court was perfectly entitled to make. What the implications are for the future of our constitutional arrangements will have to be reflected upon in the coming months and years. But it is never wise to reflect upon a court case and its implications in its immediate aftermath. It will have to be done carefully and deliberately, and this House will have to decide ultimately whether these matters and these powers are for this House to regulate and control, or whether they are for the judiciary. But at the moment, the Supreme Court has spoken, and that is the law.
Yvette Cooper.
The Attorney General's acceptance at that point that the government got it wrong in this case is very welcome. So will he now advise the Prime Minister and the government to accept and agree with the content of this Supreme Court judgment, not just the obligation to abide by its conclusion, and in particular to accept that it is wrong for this government or any government to seek to prorogue Parliament for 5 weeks rather than just for a few days without giving any reason, let alone, in the words of the Supreme Court, a good reason, to the public. This is,
Yvette Cooper, I think, getting to the crux of it, because Geoffrey Cox appears to have said that he would have resigned from Cabinet if it had been X weeks, but he was comfortable with it being 5 weeks.
The judgment is clear. The government is assessing its short and long-term implications now, but she can be quite certain that the government will abide by its ruling and by the content and implications of its judgment.
Sir John Redwood.
What limits are there on the powers of the Supreme Court to intervene in how Parliament conducts its business? And what powers are there for them to intervene over the highly political matter of when and how we leave the European Union?
I think I understood my right honourable friend's question correctly.
Question of quite spectacular boneheadedness there from John Redwood. Well done.
The court in this case was giving its judgment on a particular issue, whether or not a prorogation of this length could be the subject of judicial control, and if so, what was the correct test to apply to that judicial control.
It's approaching 12 noon. Geoffrey Cox continues to essentially explain to John Redwood how he can wipe his own nose.